Amente Beckel. Public International Law Part 1. 1. PAG. Lecture 1. Chapter 1. Nature and Development of Public International Law. 1.1. Definition of International Law. Before moving to definitions, it is quite essential to differentiate between public international law and private international law. Private international law has very little in common with public international law, and the major reason behind such dissimilarity is that private international law or conflict of laws is a domestic system of laws rather than an international one. Conflict of laws is not a system of law that regulates international affairs of states. It is an area of law that deals with cases containing foreign elements. It tries to resolve three questions: question of jurisdiction, question of choice of law, and question of execution and enforcement of foreign judgment. Obviously, providing a perfect definition for public international law, hereinafter international law, is something difficult. But as far as public international law is concerned, there are two types of definitions: 1. Traditional, and 2. Contemporary definitions. The traditional definitions focused on the fact that international law governed interstate relations. They describe international law as a body of law that deals with interstate relations exclusively. It is called traditional because the underlying assumption that states are the only actors under international law has presently changed. Though states were the only subject of international law in the past, they are no longer the sole actors, especially after the beginning of the 20th century. These new actors, subjects, are individuals. In the 19th century, individuals were thought to be under the exclusive jurisdiction of their state. Intergovernmental organizations, organizations created by states but having distinct personality different from their creators. And because of this, modern definitions have incorporated the roles of new actors. Different happenings of the 20th century resulted in the rethinking of the antiquated definition of assumptions about international law. Especially after the enactment of the UDHR, Universal Declaration of Human Rights, in the 1940s, individuals started to enjoy rights not emanating from domestic law but rather rights they got from international law. When the UN Charter was adopted, this expansion was further cemented. The Charter starts by saying, "We the peoples of the United Nations." Thus the traditional definition had to be remodeled to give the perfect picture of public international law. 2. PAG. Traditional definition. International law is a law that governs the relation of sovereign states among each other. The contemporary definitions, on the other hand, are characterized by being open-ended. Because there are more and more new actors joining the frame. For example, multinational corporations are still debatable actors, but the instructor thinks that the dust will soon settle on this topic as they have international responsibilities such as environmental pollution. Insurgent groups. International law has started imposing obligations on non-state armed groups on the case of IDP, internally displaced people, according to UN conventions. Thus, if we provide a closed definition, due to the dynamic character of international law, the definition we have provided could easily be outdated. The reason we have such expanded definition is because of 1. Expanding scope of international law, 2. The coming into picture of new players. If we go back in time, most international law scholars used to be regulating mechanisms of waging war, IHL, and also trying to define conditions that justify use of force. It also concentrated on the diplomatic relations and maintenance of international peace. These two elements formed the core of international law. But with the change of time, the focus of international law expanded, especially during the 20th century. International law started to focus on additional issues such as transportation, environment, and regulation of intergovernmental organization, regulation of satellites, human rights, refugee status, economic cooperation, trade, and investment. Contemporary definition. International law consists of rules and principles of general application dealing with the conduct of states, and of international organizations and with the relations inter se, as well as some of the relations with persons, whether natural or juridical. Third restatement. From the above discussion, one point we ought to understand is, regardless of what has happened in the 20th century, is that states still remain the most important actors of international law. International law is still dominated by states as they are the makers of international law. States form the forefronts while non-state actors are secondary. 3. PAG. Yes, international organizations also engage in the process of lawmaking. UN Security Council resolutions are binding, but their binding nature poses a general character, i.e. not always binding on other states. 1.2. Classification of international law. International law can be classified into universal and regional. Naturally, when we talk about international law, what comes to our mind are rules that apply universally. However, in reality, that is not the case, because we have regional international law. When we talk about universal international law, we are talking about rules and principles binding on all states. E.g., the prohibition on the use of force. This principle is a principle that is included in the UN Charter. However, this principle is applicable on those non-UN member states. This is so because of various justifications, but the most convincing of them all is that Article 51 of the United Nations Charter, which prohibits the use of force, is a restatement of customary international law. In other words, what they are claiming is that Article 51 and its contents already existed before the enactment of the Charter. There is also what is called general international law, which is different from universal international law rules. General international law are rules and principles that apply to a large number of states, but not each and every state. The reason why we have general international law rules than universal ones is that states as sovereign entities are allowed to have reservations or decide altogether not to join a treaty. In customary international law as well, there is this principle known as persistent objector, where a state persistently objects to the application of a given customary international law rule during its development, then that state has the right not to be bound by that customary international law rule. All these three, persistent objector, reservation and non-accession, are a reflection of a state's exercise of its sovereignty. Regional international law is where a group of states linked either geographically or ideologically may recognize certain rules and principles applying only to them. Geographically, we could mention O laws, EU laws, while ideologically we could raise the Warsaw Pact, NATO laws. 1.3. Characteristics of international law. There are a number of unique features of international law, and these are 4. PAG. International law is a horizontal decentralized legal system. International law is a horizontal decentralized legal system, as opposed to municipal laws, which are vertical and centralized. International law are horizontal and decentralized. In municipal legal systems, what we see is we have a central lawmaking organ, a determining organ, and an enforcing organ. In addition, municipal legal systems are based on obedience, command, and enforcement. For example, with regards to the newly enacted FDRE state of emergency, no subject could refuse to accept it. If it is, we could see the consequences. However, in international law, it is principles of reciprocity and consent that are an inherent part of the system. In principle, all states are equal, therefore no state can override or bully the other. In theory, the principle of sovereign equality of state means that states are situated on a horizontal plane. In international law, we don't have a strong enforcement mechanism. E.g., Ethiopia's refusal to implement the decision of the Ethio-Eritrea Boundary Commission. Such a scenario is unlikely to happen in a national legal system, as there is an execution of judgment. Self-help is a necessary tool. Help is a necessary tool. Self-help is one of the best tools to enforce one's right, which implies the lack of a centralized enforcement organ in international law. However, we do not mean that use of force could be employed arbitrarily, i.e., there are exceptional circumstances of use of force. Self-help. The other mechanisms of self-help are: retortion is a lawful act which is designed to injure a wrongdoing state, e.g., cutting of economic aid and ties, severance of diplomatic relations. These acts are legal because a country doesn't have an international obligation to lend aid nor to have diplomatic ties, as they are purely based on consent and reciprocity. Reprisal. These are acts which would normally have been illegal but will be rendered legal by the prior illegal act of the other state. E.g., a state nationalizes the property of the national of another state, this act by itself which is illegal. However, if the other nation does a reprisal act, it is not illegal. If evaluate on an individual basis, the act is illegal, but as a set it is a legal act. Because international law is a weak system in terms of enforcement, some people assert that it is not a law at all. They look at international law and its attributes through the lens of domestic law and conclude that international law should not be considered as a law, especially the positivist school of thought. For positivists, the law is the command of the sovereign backed by sanction. And on such note, a law has a sovereign. 5. PAG. Central law-making organ, which commands, that shows vertical relationship, and whose command is backed by sanction, i.e., a strong enforcement mechanism. Q. Can't we regard the UN General Assembly as a parliament and thus a sovereign? General Assembly. General Assembly, yes, it is the place where the principle of sovereign equality of the states is 100% guaranteed and respected, as Nauru and the US have equal voting power, but it is not the international parliament. Because the resolution of the General Assembly are unfortunately not binding. Security Council. Security Council, often regarded as the executive wing of the UN. In the Security Council we don't see equal representation of member states, as a Security Council membership is limited. Some countries have rotating membership status while others have permanent seat with veto powers. In principle the Security Council has no power to enact binding decisions, however on peace and security matters, the resolutions of the Council has a binding nature. Additionally, the effectiveness of the Council is paralyzed by the use of veto powers. International Court of Justice. International Court of Justice is a court whose jurisdiction is based on the consent of the states. But we should not conclude that international law is not a law. Even municipal laws, although usually complied with as they have a strong enforcement mechanism, aren't always adhered to or enforced strictly. The fact that there is poor enforcement mechanism doesn't mean that international law is fully devoid of enforcement mechanism. We should not use a comparison of municipal law with international law to decide whether it is a law or not, as there is a historical, functional and structural differences between these two set of systems. Additionally, we shouldn't only rely on the definition given by the positivist. Lecture 2 1.4. Scope of international law. Over the years there has been an expansion in scope in international law mainly caused by two reasons. First, one was due to the emergence of new things which sought the attention of not a single state but different states in a coordinated fashion. In olden times international law focused on two areas: wars are the waging of wars and the regulation of diplomatic relation, as they were used to facilitate trade between two countries. However, international laws changed during times and it now encompasses numerous elements. This expansion in scope could be attributed due to the advancement 6 PAG of technology, rules that regulate the use of the high seas, and control of new territory, maritime technology, the increasing need for global and economic interdependence between countries, international trade, economics and finance, development and environmental issues. The second reason is the emergence of new actors or subjects of international law in the form of international organizations, individuals, multinational companies and non-state armed groups. These necessitated the need in the readjustment in scope of international law, as it had to formulate new rules and principles that govern these entities. International law now covers vast and complex areas of transnational concern, including traditional topics, such as the position of states, state succession, state responsibility, peace and security, the laws of war, the law of treaties, 64 the law of the sea, the law of international watercourses, and the conduct of diplomatic relations, as well as new topics, such as international organizations, economy and development, nuclear energy, air law and outer space activities, the use of the resources of the deep sea, the environment, communications, and, last but not least, the international protection of human rights. From Peter Melanchik Akehurst's Introduction to International Law. 1.5. Theories. Where does international law get its binding force? Command theory. Common theory. The main jurist behind this theory was Gene Austin. According to the command theory, law comprised series of commands, orders issued by a sovereign backed by sanctions, enforcements. He claimed that if any of the elements are lacking from the definition, the command theory would not characterize a certain rules or principles as a law. Thus the supporters of this theory property that international law is not a law as it doesn't emanate from a sovereign command of the sovereign element, and it lacks a strong enforcement mechanism, sanction element. For the jurists under this rank, international law is not a law, rather it is a positive morality. 7. PAG. Criticism to command theory. To begin with, positive law doesn't describe national law properly, let alone international law. Not all rules in a domestic legal system are backed by sanction. There are these rules which are called permissive rules. These theory commits the fallacy of treating national law in the same manner as international law, which is a wrong premise to begin with. The purpose, function, nature and structure of these two systems are completely different. The command theory misinterprets the function of international law. International law isn't there primarily to coerce states, but rather enabling them to freely interact in a predictable and orderly fashion. This is true even in the cases of national law, with the exception of laws like the Criminal Code. Therefore, the theory cannot explain why states obey international law. Despite the lack of a sovereign power or sanction, states don't blatantly disobey it. Consent, consensual theory, consensual theory. The binding quality, nature of international law as well as its very existence as a law emanates from the consent of states. International law flows from the will and consent of states. No international law rule can be created without the consent of states which are going to be bound by it. Consent is the source of all international law obligations. But this assertion leads us to conclude that new states are not bound by pre-existing international law rules, but is that so? According to the theory, state consent may be given in different ways, expressly or impliedly. When we see states conclude treaties, we can observe that the state consent is given expressly. When a state accepts a certain customary international law, we see a type of implied consent. This is because when a certain customary international law rule is developed, states do not seat together to form it. It is developed by state practice backed by opinio juris. By giving consent, states voluntarily restrict their sovereign powers. Yes, the theory to some extent qualifies the reality of international relations related to treaties and conventions with a need for express consent, such as pacta sunt servanda, as well as implied consent in the case of customary law. Criticism to consent theory. 8 Page. Why would states be bound by self-imposed obligations all the time? Isn't it possible for states to assume obligations without their consent? Is consent necessary all the time? There are various international law rules which are not based on consent. Why is the principle of pacta sunt servanda itself binding on states themselves? Have they expressed their consent to it? New countries that emerged after decolonization, in Africa and Asia, as well as secession, the former Yugoslavia, USSR, have continued to be governed by international law without giving their consent. This is more pertinent with regards to customary law. In the case of treaties, there are two types of treaties. Dispositive treaties, which are territorial, boundary, watercourse treaties, are transferable. Some authors contend that consent is one method of creating binding international law rules, but it is not the reason why international law is there binding. Natural law theory. Natural law theory. Natural law theory stands to the polar opposite of the command theory. The source or binding nature of international law to the natural law theorists is that it is in conformity with the principles of natural justice. International law has very little support when it comes to justifying the binding nature of international law rules. Of course, natural law sometimes correctly describes the nature and validity, in limited and exceptional circumstances, of some international law rules such as equity, justice, reasonableness are slightly shown under the ICJ statutes to be employed. Some scholars also try to justify their position by referring to natural law principles or superior moral principles. Ius cogens are types of international law rules that have superior validity. No country can set aside, e.g., prohibition of acts leading to genocide. The other drawback of this theory is with the existence of different countries with diverse social, economic and cultural background, it is very difficult to find common acceptable moral principle. Practical necessity theory. Practical necessity theory. 9 Page. According to this theory, ubis societas ubiius, meaning law is necessary for any society to properly function, and because it is necessary it is binding. As international law rules are practically necessary for the community of nations to operate peacefully and orderly. This is a very pragmatic theory. Critics say that this theory commits a tautology, a circular definition. It says it is binding because it has to be binding, or we need it in a binding form. Deconstructionist theory. Deconstructionist theory. International law has no legal objectivity. It's not a law in the first place because it can be used to justify any sort of international behavior or position. International law is whatever America says. But is that always true? Realist theory. Realist theory. The advocates of this theory claim that the real importance of international law lies not in its validity of its claim to be a law, but on the impact, positive, negative, it makes on the day-to-day life of states. They believe that the usefulness of the law is necessary to determine the existence of a law. Third world approach theory. Third world approach theory. The international law system is an impartial system which supports the first world countries. It started gathering momentum after decolonization, where newly formed states claimed that they were playing on a turf and rules laid by first world nations. 1.6. Brief history of international law. International law, in a different form, with a limited scope and purpose, existed during ancient times. The Romans and even the Greeks before them knew about some international law rules like law of war, diplomatic relations. However, modern, contemporary international law is a relatively recent development. The roots of modern international law are found in European Renaissance, the development of nation-states, demarcating of boundary, claiming of sovereignty. Because the nation-states that were formed had to interact, and that new form of interaction necessitated a new form of interaction. The Renaissance period was characterized by an array of technological findings, in sailing and navigation, like never before. 10. Pag. Hugo Grotius, who is credited for being the father of modern international law. Among his contribution are the principle of the freedom of the high seas, all countries enjoy equal access to the high seas. He also developed international law regulating war, i.e., rules regarding the use of force, prevention as well as just war. The other very critical moment when modern international law continued its development was before and after the Second World War. Before, as the League of Nations was created and its covenant prohibited the use of force, and the PCIJ, Permanent Court of International Justice, was formed. After the war, various other attempts were made with the creation of the UN, development of human rights and the signing of multiple conventions. Lecture 3. Chapter 2 Sources QQ. What is the difference between formal, legal, and material source of law? When we are talking about formal sources, we are talking about sources in the legal sense. We are referring to lawmaking sources, we are referring procedure or methods by which rules become legally binding. We are talking about the requirements under which rules become binding. On the other hand, when we are talking about material sources, we are talking about sources in the historical sense. Material sources tell where the law is to be found, while formal sources describe what the law is. The distinction between formal and material source of law underlines the distinction between de lege lata and referenda. In Latin, these classification between de lege lata, meaning the law as it is, actual law, and de lege referenda, the law as it may be in the future, as it should be. In international law, when we are talking about formal sources of law, we are talking about de lege lata, the actual law, while when we say de lege referenda, it doesn't necessarily imply the law as it stands. QQ. What are the sources of international law? It is Article 38 of the Statute of the ICJ, carbon copy of the Statute of PCIJ, that is usually accepted as constituting the source of international law. However, Article 38 doesn't say the following are the sources of international law, rather it tries to give the court a 11. Page. Direction, guidance as to what sources it should consider when it disposes cases containing an international disagreement. It is dominantly used as the document leading to the possible sources of international law because there is no other document explaining better the sources of international law. However, this article is the perfect one, but rather the better one. There are a number of criticisms pointed on Article 38. It doesn't list all sources of international law. Additional sources have evolved as sources of international law, e.g. resolutions of international organizations. Security Council resolutions passed under Chapter 7 are binding with respect of that matter, ILO's rule-making power, tripartite law-making power between states, representative of employers and employees through trade unions. It includes aspects of sources which are not genuine sources. There are primary and secondary sources under Article 38, judicial decisions and learned writers forming secondary sources. These subsidiary sources are regarded as non-genuine sources as they are used to elaborate the contents of the primary sources of law. But the instructor thinks that subsidiary sources are still crucial and relevant despite being second-tier to primary sources. It doesn't provide hierarchy amongst the sources provided, with the exception of differentiating primary and secondary sources. But how about between A, B, and C, one hand, and D, and E, on the other hand? Generally, we have 5 sources of international law: 1. Treaty, 2. Custom, 3. General principles of law, 4. Judicial decisions, and 5. Teachings of reputable scholars. 2.1. Treaties. International conventions or treaties are the only way by which states create international law consciously or deliberately. So unlike customary international law, which develops sometimes without the knowledge of some states' consent, treaties develop with the consent of the parties bound by it. Treaties are now the most important source of international law, overtaking the previously dominant custom. Treaties could be bilateral, particular, or multilateral, general. Once a treaty satisfies a formal requirement, a treaty imposes obligations on states that are party to it. If a state party fails to abide by that treaty, that state will incur international obligations. A treaties bind only parties to them, principle of privity. A state is bound by treaties only vis-a-vis other state parties and not in relation to other non. 12 PAG. Contracting states. However, there are exceptions to such principle, e.g. dispositive treaties. Territorial treaties bind new states that have seceded from the contracting state. This is so because these kind of treaties in their nature prescribe rules regarding common interests. The other exception is when a country which has not acceded to a treaty which has converted an existing customary international law rule is bound by rules within the treaty despite not being party to them. Logically, this is the case because the state is not being bound by a treaty it didn't consent to but rather by the pre-existing customary international law rule applying to all states. B. There is a theoretical debate as to whether treaties impose legal obligations or not. There is a difference between mere obligations and legal obligations. The difference could be clearly dealt out in one phrase: are treaties laws? Do they create obligation or law? Because of these, scholars have come up with two types of treaties: contract treaties and lawmaking treaties. Contract treaties are usually bilateral treaties which impose or create obligations and only on state parties to those treaties. On the other hand, multilateral treaties are usually regarded as law-making treaties as they usually create obligations or law on parties to the treaty as well as to non-member states, sometimes. But doesn't this contradict with privity of treaties? Yes, but most multilateral treaties usually codify pre-existing customary international law rules which are binding, in principle, on all states. 2.2. Customary international law. Customary international law is a law which has evolved from practice or custom of states. So when we talk about customary international law, we talk about the conduct or behavior of states. However, the conduct by itself is not sufficient as the psychological element is equally necessary. Thus, customary international law rule is composed of two elements: the conduct element and opinion juris element. The conduct element is the material element which consists of actions or omissions of states, and nowadays actions of non-state actors. Opinion juris, accepted as law, under Article 38 of the ICJ statutes, on the other hand is the psychological element which is the belief on part of states that acting or refraining to act in a certain manner is their legal duty. This element is very essential as it enables us to distinguish mere usage from legally binding custom. The 2.13 PAG elements have to be cumulatively satisfied for an act or omission to serve as a binding international custom. Courtesy acts are not binding custom. Custom was the foundation stone on law of nations before the coming into picture of treaties. However, presently customs have taken the forefront of modern international law. Custom is always available to fill the void of treaties. Custom enables international law to develop with the needs of time as they are flexible. The amendment of custom requires a formal process while the change in custom only requires a change in practice. But the problem with custom is that it has uncertainty and lack of speed in development. In principle, it takes time. Lecture 4. The state practice itself has sub-elements. It has to fulfill some requirements. These requirements are consistency, uniformity, generality and duration. When we read Article 38(1)b of the Statute of the ICJ, it doesn't talk about any of these criteria. However, these standards were developed by the ICJ and PCIJ in their previous decisions. Consistency. The state practice in question must be reasonably consistent. That given state practice of different countries should follow the same path and there should be no contradictions. However, the requirement should under no circumstances be interpreted as requiring a complete consistency, but rather a substantial consistency. Because if we require total consistency, that would be a very difficult test to pass through. This rule of substantial consistency was laid down in the Lotus case. In the Lotus case, the PCIJ stated that state practice has to be substantially consistent. It also indicated that there is no requirement for complete or total consistency. The Lotus case was a case brought before the Permanent Court of International Justice (PCIJ) in the year 1928. Two steamer ships collided on the high seas, one belonging to Turkey and the other to France, with casualties. One of the major issues involved in that case was the issue of jurisdiction. When Turkey apprehended, for voluntary manslaughter, the French guy who was in charge of Lotus, the French ship France opposed, claiming Turkey lacks criminal jurisdiction. In making this assertion, France was heavily relying on customary international law. In almost all circumstances where an offense was committed in the high seas, then the flag state is the only country that has jurisdiction over such criminal matters. Finally, the court did not accept France's assertion as a whole due to the non-fulfillment of opinio juris. 14. PAG. Uniformity. The uniformity standard was reflected in the North Sea continental shelf cases. These were originally two cases between Netherlands versus Germany and Denmark versus Germany, which were later joined. In the North Sea continental shelf cases, the issue was on how to delineate the continental shelf. In the law of the sea, there is this notion or concept known as continental shelf, which simply means part of the sea next to the coast of the state that is considered as the territorial waters of coastal states. Germany had a different view of definition compared to the Netherlands and Denmark. ICJ suggested that state practice, including that of states whose interests are specially affected, had to be both extensive and virtually uniform. However, the criteria of virtual uniformity is a one which can't be optimally fulfilled by various cases, thus the ICJ changed its stance in the 1984 Nicaragua case. The criteria of virtual uniformity was replaced by general uniformity. So under present international law, state practice doesn't have to be virtually uniform. The fact that there are minor inconsistencies or minor deviations doesn't bar the development of a given state practice from being a customary international law rule. Q. What is the difference between consistency and uniformity? When we are talking about consistency, the first action and the following action of a given state must not differ. However, both criteria have similarity in that they don't want contradictions. In another case, the Anglo-Norwegian fishery case, the ICJ emphasized that the degree of consistency required might vary based on the subject matter. Such principle applies to uniformity as well, as they are closely related. In the Anglo-Norwegian case, the court decided that the degree of consistency and uniformity required is not necessarily the same for all state practices. It differs from one subject matter, nature, to another. For example, regarding obligation imposing rules, there has to be more consistent practice than rules imposing passive obligations. Generally, in international law, all kind of rules can be put into two baskets: rules that limit the sovereignty of states, the do-nots, and rules that allow sovereignty, the do's. The Anglo-Norwegian case decision said that normally when it comes to obligation imposing rules, more consistency and uniformity is required. It was 15. PAG. Also pointed out that an even higher level of consistent contrary state practice is required to change fundamental customary international law rules. On the other hand, less fundamental rules require less consistency. The Nicaragua case, Nicaragua versus USA. In this case, it was that mere existence of new state practice doesn't mean development of a new rule. This is a very good test, and existence of a new contrary state practice doesn't imply existing rules are automatically changed. The conditions for changing an existing customary law becomes more vigorous compared to developing a new customary international law rule. Continuity and repetition. The basic rule with regards to continuity and repetition was based on the asylum case decided by ICJ in 1950. Asylum case. This was a case brought by Colombia against Peru. Colombia had a diplomatic mission in Lima, Peru. In Peru, a coup had taken place, and the leader of that coup, when he realized that the coup had failed, sought asylum inside Colombian embassy in Peru. Peru insisted that Colombia should hand over the guy because there is no international law rule that allows Colombia to try the person. On the other hand, Colombia said that I can characterize the offense committed and try the Peruvian in Colombia. Thus, Colombia requested for Peru to allow the individual to fly and be tried in Bogotá, Colombia. It is a landmark case as it talks about regional custom. Just as we have bilateral, regional treaty, in this case it was acknowledged that there could be regional custom. The rule of diplomatic asylum developed mainly under the Latin American context. The court did not accept Colombia's argument, but at the same time it asserted that Peru couldn't ask Colombia to hand over the suspect. Interestingly, the right of Peru to refuse the flying out of this man created a deadlock, similar to the Julian Assange case. The difference between diplomatic and territorial asylum is where the asylum is actually requested. In territorial asylum, the asylum is requested within the territory of the receiving state. Contrastingly, diplomatic asylum is requested in the embassy or ships carrying the flag of the receiving state. 16. PAG. The court declared that customary rule should be in accordance with the constant and uniform usage practiced by the states in question. Some authors argue that the principle of repetition and continuity is embedded in the principle of uniformity and consistency. Generality: for a universal or a general customary international law rule to develop, the practice must be fairly general. However, this requirement of generality doesn't apply or loses power when it comes to regional customs. By generality we mean that a significant amount of states need to support the practice for it to be a custom. By generality we don't mean that every state should support it, unanimity or universality, but rather general customary law. The degree of generality varies from case to case. The degree of generality is higher for rules limiting state sovereignty as compared to rules enhancing state sovereignty. There are limitations on the requirement regarding generality. Special weight is given to the practice of relevant states. In relation to the subject matter, the voices of some states could be louder than unconcerned states. If we are talking about rules governing maritime law, then the practice of coastal states is more important than landlocked countries. If we are talking about state practice relating to outer space, obviously the practice of countries that are actively involved in such expeditions is important: China, Russia, USA. This, however, by means asserts that some states are more powerful than others. International law theoretically considers all countries to be equal, the principle of sovereign equality of states. The theory of persistent objector is also considered as an exception to the rule of generality. When a state objects from the beginning to a particular practice or carries out a contrary practice, that state may not be bound. There are two important elements. 1. The objection has to be mounted from the onset, it has to be expressed initially, and 2. The objection has to be persistent. In the Anglo-Norwegian fisheries case, when there was a dispute regarding the extent of territorial sea, as opposed to high seas between the UK and Norway, UK claimed the existence of a certain customary international law rule which is binding on all states that Norway isn't accepting as a violator. ICJ concluded that Norway shouldn't be bound by that customary law as it was persistently objecting to this particular state practice to the extent that other countries should know or should have known. 17. PAGE. The third exception is the existence of a local custom. Such local custom doesn't require the existence of general support or generality. Duration. Duration as a requirement is different from repetition. As in duration we are talking about the amount of time that should lapse before a given practice becomes a customary international law rule. Malcolm Shaw claims that duration is not the most important element of state practice. Duration can be one requirement sometimes, but we should not always insist of the fulfillment of duration requirement. ICJ also accepted this requirement under different cases. In the North Sea continental shelf cases, ICJ stated that 1. The length of time required differs from case to case. 2. The passage of a brief time is not necessarily a bar to the formation of customary international law rule. Thus, key principle of instant international customary law was born. Professor Bin Cheng claimed that it is possible for a customary international law rule to develop instantly. In most cases a passage of time is required, but they can never rule out the instant development of an instant customary international law rule. This can be exemplified in the dynamic aspect of international outer space rules. Opinio juris necessitatis. Once we have ascertained the existence of state practice fulfilling a certain state practice, we still have to look for the mental element. This is an important rule that distinguishes customary international law rule from usage. Unlike state practice, it is extremely tough to prove opinion juris. It is the belief on part of states that acting or refraining to act in a certain manner is their legal duty. Acquiescence is a rule which states that if a state remains silent or idle in the development of a certain customary international law rule, it would apply to it. Lecture 5 2.3. General Principles of Law. From the reading of Article 38, we could ascertain that general principles of law are primary sources of international law. However, it is a known fact that treaties and customs supersede general principles of law. We say this because international law is a system which is primarily created by states. In both treaties, directly, direct expression of consent, and custom, indirectly, indirect expression of consent, states are involved in the creation. However, general principles are different, in the sense that they don't require the consent of states. 18. PAGE. Q. When we are referring to general principles of law, are we referring to principles of international law, such as sovereign equality of states, or national law, such as res judicata? Article 38(1)(c) doesn't talk about such distinction or which one applies as a matter of fact. However, most scholars agree that it applies to both national and international law principles as a gap-filling choice. Exhaustion of local remedy is a general principle that originates from the national system, but we see it being applied by various international tribunals, human rights courts and commissions using this principle. General principles of law seen from the lens of theories of law, especially with regards to recognition of general principles of law as sources doesn't go well with the positivist command law approach. 2.4. Judicial decisions. When Article 38(2) says that judicial decisions and teaching of scholars are to be seen as a subsidiary source, it is sending a message that these cannot be considered as law-creating sources but rather as law-elucidating, determining or defining sources. Article 59 of the Statute of the ICJ confirms that judicial decisions are indeed not considered as law-creating sources. The article deliberately excludes the principle of stare decisis from the international legal system. It provides that decisions of the ICJ are binding only on parties to that given case and only as regards the matter in question. Thus, a contrario reading of Article 59 dictates that the principle of precedent is effectively excluded from the international legal system. Purely seen from a legal point of view, the court doesn't have a lawmaking power. But in practice, what we see is the ICJ heavily relying on its decisions rendered previously. It does this for various reasons such as consistency and its attempt to influence the development of international law. However, states would love to preserve the lawmaking power for themselves. ICJ has two types of jurisdiction: advisory jurisdiction and contentious jurisdiction. When ICJ gives decisions based on its contentious jurisdiction, the decision would be binding on the parties to the case. In its contentious jurisdiction, the court handles disputes. The advisory jurisdiction doesn't entertain disputes per se, and opinions of the ICJ are not 19 PAG legally binding. The advisory opinions, despite not being binding, has an influential character. Thus, states usually prefer to abide by ICJ advisory opinion. Q. When it says judicial decision, is it referring to the ICJ or also other courts? Generally, the reference towards judicial decision is to different judicial and quasi-judicial bodies, such as ICC, ICTY, ICTR, U.S. Supreme Court. 2.5. Learned writers. The writing of the most highly qualified publicist is considered as the second form of subsidiary international law rule. Writing of scholars cannot create law, but this can be used as law-determining material source of law. During the formative stages of international law, the role writers played was quite different from present perception. For example, Hugo Grotius's book was not only considered a book but was also regarded as a rule, law. Not all writings qualify as subsidiary sources, they have to be writing of renowned and acknowledged writers. In the Spanish Zone of Morocco case, Judge Huber asserted that in most circumstances writers are politically motivated. 2.6. Other possible sources. We have said that the list under Article 38 of the ICJ is incomplete from the outset. Resolutions of international organizations, such as General Assembly resolutions. Yes, they are non-binding, however they contribute towards the development of international law, both treaty law and custom, and clarify the content of an existing customary law. So shouldn't we consider such resolutions as secondary sources of international law rule? General Assembly resolution on the definition of aggression passed in the year 1974 is a very powerful definition. Security Council resolution passed by the Council under Chapter 7 are binding. Soft law is a term of act used to describe two different notions. The first one is that soft law are rules of international law that do not stipulate concrete rights or obligations but which have normative value. They are legally binding but fail to provide clear obligations and rights. They are vague and quite flexible. Most rules under environmental law, reparation obligation, is regarded as being soft law. Article 2 of the ICESCR states that countries have obligation to take steps individually or through international assistance with the view of achieving economic development, but what does this mean in practical terms? 20 PAG. The second notion of soft law is de lege referenda. It doesn't have a normative value or impose legal obligation, but it tells you the opinion of some countries or people what the law should be or may be in the future. It might shade some light of what the law would look like in the future, so soft law in the second notion might shape state behavior. Lecture 6 2.7. Hierarchy of sources and jus cogens. Q. What happens when a treaty contradicts an existing custom? What happens when a treaty complements an existing custom? When we talk about hierarchy of laws under international law, we are normally talking about the position of treaties and custom. And we are talking about them under two situations: when they complement, supplement, and when they contradict. When custom and treaty complement. This happens when there are parallel obligations imposed by both custom and treaty. Custom was the pre-existing one and a treaty, which is complementary, comes afterwards. That is normally the case under international law. Treaties reflect the consent of states to be bound by them in an equivocal manner. Additionally, the contents of treaties are more or less clear and certain in comparison with international custom. Thus, as treaties have this advantage, if you find a customary international law rule predating a given treaty, in principle, it should be a treaty that should take precedence as far as members to that treaty are concerned. This could be also explained in terms of the law that comes later prevailing over the law that came prior. Rule number 1. When you have a treaty and custom complementing each other, and when the treaty comes later in time as far as member states to that given treaty are concerned, it is the treaty that governs their relations. But for non-member states, it would be the customary rule which will bind them. In the Nicaragua case, the ICJ provided another principle, saying that custom doesn't cease to bind states even if the state has become a party to a treaty. Thus, the decision have further qualified the rule by claiming that it is both custom and treaty that apply to the member state of a treaty. In the Nicaragua case, the United States, which was a member of the UN Charter that provides for the prohibition on the use of force, 21 PAGE, which the U.S. had reservations on the ICJ statute of the court having jurisdiction on the American obligation arising out of multilateral treaties such as the UN Charter. But the court concluded that America, despite not being bound by the prohibition on the use of force under the Charter, is at the same time as one state of the world bound by customary international law rule regarding the prohibition on the use of force. Thus, in principle, when we have treaty and custom having the same, similar content, a treaty that comes at a later time prevails. However, as an exception, that doesn't totally displace the application of that customary international law rule. Q. Why do we bother to put the two sources under a ladder if they both lead to similar conclusion? We didn't say that the treaty and custom are identical but rather complementary. Thus, there could be possibility for a difference in application. The other exception relates to obligations erga omnes, ius cogens. Ius cogens norms are fundamental norms of international law from which a state cannot derogate. Thus, with respect to erga omnes norms or ius cogens, the principle under Rule 1 doesn't apply, meaning a treaty coming at a later time will not prevail. This is due to Article 53 of the Vienna Convention on the Law of Treaties, which states that a treaty is void if at the time of conclusion it conflicts with the peremptory norm of general public international law. There is little consensus on the content, subject matter of ius cogens norms. Few of them regarding which there is consensus are prohibition of genocide, prohibition on the use of force, and self-determination. Recently, when custom and treaty contradict, here again we apply interpretation rules relating to time. The law that comes later should apply better than the law that came out prior. The other rule of interpretation used is specific rule prevails over general rule. Custom or treaty imposing particular obligations prevail over one that imposes general obligation. This principle, however, is qualified by Article 53 of the Vienna Convention on the Law of Treaties. Q. What do you do when a custom comes later to a treaty and they contradict? The fact that states have concluded a treaty doesn't mean that there isn't going to be any change in the future. Practically, countries have a perfect way of amending treaties. Theoretically, there is a chance where a custom could possibly amend a treaty. Practically. 22 PAGE. However, it is almost impossible for an unclear and uncertain custom to replace a ready-made, clear and certain treaty. The content of customary international law rule has to be very clear and strong state practice supported by a certain and unequivocal opinion juris for it to replace an already existing treaty. Chapter 3 International Law and Municipal Law. Under this chapter we will be talking about the interaction between national law and international law. The discussion becomes pertinent especially when these two laws contradict. 3.1. The theories, monism versus Dualism, monism. Monism considers international law and national law as belonging to the same legal order, and it treats them as different versions of a single body of law. They operate concurrently over the same subject matter according to the monist school of thought. As they operate concurrently, contradiction is a possibility. And when a conflict arises between the two, international law prevails, and international law is considered as having a higher position or a better standing in the ladder of hierarchy. Dualist pluralist assumes that international law and municipal law are two separate legal systems which exist independently of each other. One deals with interstate relations and the other intrastate matters. Thus, for dualism, if a person has a right under international law but not municipal law, courts would apply national law. Dualism emphasizes sovereignty, so it tends to rely on positivist school. In cases where there is a contradiction between national law and international law, the dualist law suggests that international law would prevail on international matters and national law would prevail under national law. A state's action could be unlawful under international law, but it can still justify its action under its national law. For dualists, states can enact national laws that contradict its international duty. In such cases, the state will, of course, be held liable under international law, but nationally it can justify its actions. Lecture 7 3.2. The role of municipal rules in international law. 23 PAG. Q. How do international courts treat national laws? When do they make use of national laws? National laws are, sometimes, used as sources of international law. International law uses national law in determining the contents of a given international law rule. National law can clarify state practice to determine the contents of a given international law rule. International law uses national law as a law-determining source. Sometimes the court is allowed to use general principles of law as primary source in the form of general principles of law. And when we were talking about the contents of this general principles, we have said that sometimes this general principles could be national principles of law. Secondly, international law sometimes leaves certain questions to be handled by national law. The question of nationality is a perfect example in such regard, as international law uses nationality as a test to apply certain international law rules like refuge law. International law doesn't determine nationality but rather leaves it to national laws. However, the general rule of international law provides that a state cannot plead a rule or a gap in their own national law as a defense to a claim under international law. During a state of emergency, the right to life can never be derogated for the UN Human Rights Commission. But if the Ethiopian government kills individuals under the existing state of emergency and was called upon by the international community to justify its act, it can't defend that it took the action because it is entitled to do so under its national laws. This general principle is applicable regardless of the state's adherence to monism or dualism. Normally, if it had accepted monism, it wouldn't have raised such argument as in monism. When there is contradiction, international law prevails. This rule is incorporated under Vienna Convention, Article 27, on the law of treaties. This theory dictates that international law is always dominant or has the upper hand in the international setting. So sometimes international law treats national law favorably by referring to it, and at times opts for an uncompromising position. A corollary to this principle is that states have to perform their obligation under international law in good faith. They have to do their level best to perform such duty. States have also the duty to conform their national laws to their international law obligations to which they have consented. 3.3. International law before municipal courts. 24 PAG. Different states have different attitude towards the application of international law. Laws of developing countries, in the past, that are keen on emphasizing their sovereignty do not give primacy for international law over their own municipal laws. They usually adopt the dualist approach. A large body